So the government is literally, and I mean literally, locking people up in jail for defying stay-at-home orders as relates to the My Sharona Cyrus, while simultaneously freeing prisoners from jail because of concerns over the My Sharona Cyrus.
Let that sink in.
Viva Frei, Montreal litigator turned YouTuber, still on lockdown, therefore still doing vlogs from my car at that time of the day when the kid sleeps in the back. Every now and again, I hear a story that is so seemingly outlandish on its face that I think I must have misunderstood something, or I think the story must have been misreported somewhere. And this is one of those stories. The story is of one Shelley Luther, a Dallas, Texas salon owner who apparently was just sentenced to 7 days in jail for violating a temporary restraining order as relates to executive orders for lockdown in her city. And when I first heard about the story and read the headlines, I said there has to be something more to this story because it just doesn't make sense. But spoiler alert, that is effectively what happened with some small nuances in law. I'm going to break it down and explain the nuances in non-legalese, but yes, Shelley Luther was in fact sentenced to 7 days in jail for violating an executive order and opening her business to the public in the context of the My Sharona Cyrus before she was allowed to do so. And with this story, we are in fact living in the alternate reality where people are in fact being locked up for defying stay-at-home orders as relates to the My Sharona Cyrus, while inmates are being released from prison because of risks of the My Sharona Cyrus. Try to make sense of that in your head. And in case it wasn't obvious, it's tongue-in-cheek when I say try to make sense of this. It is impossible to make sense of this because we are literally living in a bizarro universe. But what is going on with Shelley Luther? The overview of it is that Texas Governor Greg Abbott had issued an executive order basically ordering people to stay at home and shutting down non-essential businesses. The executive order was scheduled to expire on April 30th, but the Dallas County apparently extended that executive order until May 15th, thus not allowing non-essential businesses to open until at least May 15th. Now, the first question some people are asking is whether or not these executive orders even have the force of law. Full disclosure, I am merely a Quebec attorney. I am by no means a United States constitutional law expert, but I have, in the course of my YouTube career, developed some contacts whom I do ask some questions to from time to time. That, and I am also able to do some independent research on my own. The short answer is yes, executive orders once issued have the force of law. As far as constitutional law in the United States goes, states are in fact afforded broad authority as relates to police powers. Individual states have constitutionally afforded police powers when it comes to health, safety, morals, and general welfare. And when it comes to situations of emergencies, as we've seen in New Jersey, Michigan, Texas, California, these police powers are virtually limitless. Virtually limitless powers, but are nonetheless subject to the constitutionality of the executive orders in question. So bringing it back now to Shelley Luther of Dallas County. The executive order, let's just call it the stay-at-home order, was scheduled to expire on April 30th. That executive order was apparently extended through May 15th, at the very least in Dallas County, and Shelley Luther said, no, enough is enough. I'm opening up to the general public now. Apparently, Dallas County sent a letter of demand to Shelley Luther enjoining her to comply with the executive order and close her business to the general public at least until May 15th. When Shelley Luther did not comply, Dallas County apparently petitioned the court and obtained a temporary restraining order, which is basically like an injunction enjoining Shelley Luther from operating her business. Now, it's important to appreciate a temporary restraining order is in fact an order of the court. And so when Shelley Luther did not comply with that temporary restraining order, she was in fact in contempt of court by the strictest letter of the law. Oh boy. When someone wakes up angry, you know you're going to be in for a fun evening. Woo! You want to go watch Ghostbusters 2? Can you call? So Shelley Luther, in an act of defiance, continued to open and operate her hair salon in defiance of the temporary restraining order that was issued against her. Now, apparently she was implementing some safety measures within the salon, but that is all secondary to the issue. She continued to operate her business in violation of the temporary restraining order, and she was brought back before the court to face charges of contempt. I've talked about contempt before in previous vlogs, most notably the Tommy Robinson contempt situation. When it comes to contempt, you have two types of contempt. You have in facie contempt and you have ex facie contempt. In facie contempt is pretty much what it sounds like. It is contempt in the face of the court, like behavior in the courtroom that is so offensive it constitutes contempt in the face of the court. Ex facie contempt is the opposite. It is contempt that is not committed in the face of the court. And the typical example of ex facie contempt is not respecting court orders or judgments of the court. For example, in the context of trademark violation, what's going on here? If there's an order of the court enjoining someone not to infringe on the trademark of another, and then like a week after the judgment is issued, you find that person infringing on the trademark yet again, that constitutes contempt ex facie. So Shelley Luther is brought back to the court on charges of contempt for having violated the temporary restraining order enjoining her not to open or operate her business. and the judge finds her guilty of contempt. Now, I don't know exactly what the rules are in Texas when it comes to punishment for contempt, but I suspect they're virtually identical to the rules for contempt in Canada. When it comes to the punishment for contempt, it can be a fine. It can in fact be a pretty hefty fine. It can in fact result in imprisonment, which is why contempt is considered to be quasi-criminal proceedings. Punishment for contempt can result in imprisonment, as we saw with Tommy Robinson. Not only that, but the punishment can be imposed continuously until the individual complies with the court order. Just to take the most extreme example, there was a story of a lawyer who spent 14 years in jail because he refused to produce documents to show where his money went in the context of a divorce. And I've got to say, to spend 14 years in jail because in the context of a divorce, you don't want to produce documents to show where your money is so your ex-wife can get it, you've got to hate your ex-wife more than you love your own life.
That rhymes.
Shelley Luther was sentenced to 7 days in jail, ordered to pay a fine of $3,500, I believe, plus $500 a day for every day she continues to violate the court order. Now, if you don't find this story shocking enough, just wait until you hear what the judge said to Shelley Luther at her hearing.
That you now see the error of your ways and understand that the society cannot function where one's own belief in a concept of liberty permits you to flaunt your disdain for the rulings of duly elected officials, that you owe an apology to the elected officials whom you disrespected by flagrantly ignoring and in one case defiling their orders, which you now know obviously apply to you. That you understand that the proper way in which in an ordered society to engage concerns which you may have had is to hire a lawyer and advocate for change, an exception or an amendment to laws that you find offensive, that you publicly state that this is the way that citizens in the state should behave, and that you represent to this court that you will today cease operation of your salon and not reopen until after further orders of the government permit you to do so. This court will consider the payment of a fine in lieu of the incarceration which you've demonstrated that you have so clearly earned. Is there anything that you would like to say?
Now, I genuinely hate drawing hyperbolic historical examples, but just listen to the words of the judge and imagine under what other historical circumstances those words could have been said.
That the society cannot function where one's own belief in a concept of liberty permits you to flaunt your disdain for the rulings of duly elected officials.
Now, although I do very much hate drawing hyperbolic historical analogies, I do very much appreciate making literary connections, and the words of the judge remind me of something I once read.
He gazed up at the enormous face. 40 years it had taken him to learn what kind of smile was hidden beneath the dark mustache. Oh, cruel, needless misunderstanding. Oh, stubborn, self-willed exile from the loving breast. 2 gin-scented tears trickled down the sides of his nose. But it was all right. Everything was all right. The struggle was finished. He had won the victory over himself. He loved Big Brother. George Orwell, 1984.
Apologize. Admit you were wrong. Say you won't do it again, and you get to keep your liberty and property. This reminds me exactly of what CNN did when they threatened to dox that kid for having made that Trump meme. And from what I understand, this extension of the original executive order is set to expire in a week or two in any event where non-essential businesses will in fact be allowed to be open to the general public. This judge is imposing jail time, the most severe sanction for a finding of contempt for contempt that in a week or two will actually be without object. The judge could have imposed a fine, a hefty fine, even a hefty daily fine, because at the very least, money can be reimbursed on a successful appeal. But you know what can't be reimbursed on a successful appeal? A week of someone's life. And typically, imprisonment for contempt, at the very least in Quebec and Canada, is a very exceptional situation. This is the real-life version of Big Brother beating Winston into submission, and if you haven't read 1984, go read it now. But when it comes to Shelley Luther, she is not taking Winston's way out.
Disagree with you, sir, when you say that I'm selfish, because feeding my kids is not selfish. I have hairstylists that are going hungry because they'd rather feed their kids. So, sir, if you think the law is more important than kids getting fed, then please go ahead with your decision, but I am not going to shut the salon.
Luther's attorney, Warren Norrid, vowed to appeal the decision. He said the salon would likely continue to open its doors, increasing the $3,500 fine against it by $500 each day it does before the governor's new order takes effect Friday. And in case it's not abundantly clear how I feel about this, yes, there is the law. And if that is the law, then the law is an ass. And if the law is an ass, then the punishment for breaking that ass of a law is an even bigger ass. It's not just that the contempt charges become without object as of this Friday, according to that article. It's that the punishment is excessive and entirely unjustifiable given the contempt charge itself. This judge is literally imprisoning a woman for violation of a My Sharona Cyrus executive order while they are literally releasing prisoners from jail as a result of the My Sharona Cyrus risks. It is impossible to reconcile those two realities, period. Now, I have gotten myself worked up, but with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment, but above all else, take care of yourselves, stay safe, stay healthy, and now you know your vlog. Peace out. Booyah!